Good morning, everybody. My name is John Dean, and I'm a partner with Gannons. And this morning I'm joined by Alex Kennedy and Yaz Barber from the Gannons dispute resolution team. This morning we're talking about some of the potential problems faced by young businesses and inexperienced or experienced founders when they start entering into contracts. And we're talking about ways of navigating a pathway to a solution to those problems via dispute resolution. We're looking at trying to avoid litigation, but where litigation can't be avoided, we're looking at minimizing the impact of litigation on a business. And we thought we'd start by giving you some idea of the types of claims that we are asked to get involved with, which relate to or concern young businesses and founders. The first type of claim is disputes involving founders themselves. A common scenario is that founders might come together and for whatever reason they no longer wish to continue working together. And yet they both want to continue with the activities of the business. And this kind of dispute would often involve a consideration of splitting clients and possible future profits and the sharing of IP and the sharing of data in the two new businesses that might emerge. Another common scenario is that a founder might refuse to continue working in the business and at the same time refuse to hand over the shares that they have in the business, shares which have an equal right to dividends and voting and so forth, as the shares which are held by the founders who continue working within the business. Another common problem is that three or more founders might come together. They would have a mutual expectation of continued involvement with the management of the business for so long as they own shares in the business. Things might go wrong, and a majority of those founders might exercise their voting rights as shareholders to remove one of their number as a director, thereby excluding that director from involvement with management of the business. Very common scenarios that we encounter. And in many of the situations that we come across, there's an absence of any documentation. There's no shareholders agreement that might have nice dispute resolution or deadlock resolution provisions. There are no provisions dealing with compulsory transfers of shares. There are no provisions dealing with restrictive covenants on exit. And we tend to find that there isn't any service agreement that might contain obligations of time commitment to the business. Commercial disputes that we come across, which are common to young companies, obviously unpaid invoices, whether they're invoices which have been rendered or invoices which have been raised by suppliers. And they're often accompanied with claims for breaches of contract. And those breaches might be the reason why the invoices remain unpaid. It can be late delivery, it might be substandard services that have been provided, or it could be substandard deliverables. We have many IT service contracts and IT development, software development contracts that go wrong. And so we have to navigate solutions with those. Whilst we don't do landlord and tenant litigation here at Gannons, we're fully aware that many of our SME clients do experience problems with landlords, whether it's about rent and whether it might be about dilapidations, liability for dilapidations at the end of the lease. Intellectual property disputes, which are common amongst young companies, are disputes with the suppliers and the consultants that might have been commissioned to develop or design software, website content, or a logo. And there's no clear documentation of who owns the IP rights in those items. We've come across many intellectual property infringement claims, whether they're claims by the company against third parties or by third parties against the company, whereby they're saying that the use of a trademark, copyright, or a design is without the owner's permission. And finally, with IP rights, a common scenario is that we might assist clients with getting involved in opposition applications where trademarks have been registered at the Intellectual Property Office by competitors, which are the same as or similar to trademarks used by our clients, whether those trademarks are registered or unregistered. Employment disputes are frequent, and they most commonly involve defending claims brought by employees under contract or the employment rights legislation. and there'd be claims for unfair dismissal, for example, wrongful dismissal, constructive dismissal. There might be discrimination claims or whistleblowing claims. We also assist clients who are pursuing ex-employees for breach of their post-termination restrictive covenants. And we also get involved in pursuing disgruntled or ex-employees who've been accused of theft of data or theft of confidential information. With data protection, we assist many of our young companies with responding to data subject access requests and understanding whether those requests might be too far wide in their ambit or scope, and whether more time is needed than the 31-day limit to respond to the data requests. We also are seeing a rise in the types of claims brought by claimants under the data protection legislation, UK GDPR, claiming damages for distress that might have been caused by a data breach. So that's an idea of the types of claims that we get involved with, which involve young companies and founders. And we try to assist with navigating a pathway to a solution by dispute resolution. And whilst we would say here that business disputes are inevitable, litigation is not. But what litigation is in fact expensive, time-consuming, it's stressful, and it involves the diversion of financial and non-financial resources away from where they're most needed. If it's not possible to avoid litigation, then you should try to resolve and get out of the litigation as quickly and as cost effectively as possible, because the longer litigation goes on, the more frustrating and the more costly it becomes. And litigation can in fact be the making or the breaking of a young company. So against that background of the types of claims that we get involved in, I now hand over to Alex, who'll give a brief overview of the court's rules in the context of some of these claims.
Thanks, John. We're going to be talking a lot this morning about litigation risk. So that's the risk that you lose at trial. The rule in England is that if a party loses at trial, they will be generally liable for the winner's costs. So if you lose at trial, you might find that you're responsible for paying an award in damages, your own legal costs, and the legal costs of the other side. And these costs can be really quite significant and should be at the forefront of everyone's mind as they decide how to conduct themselves throughout the litigation. As John said, litigation has always been unpredictable, time-consuming, and costly. In 1999, there was a real concerted effort to improve the situation by sweeping away all the common law rules and replacing them with a single procedural code known as the Civil Procedure Rules, or CPR. These are intended to govern the entirety of the parties' interactions throughout the litigation process, and importantly, they can arise before litigation occurs, before the courts are ever engaged, once the dispute arises. And there can be consequences for non-compliance with the civil procedure rules. So as an example, let's say that you as a party or anticipated party to litigation makes a reasonable settlement offer, but your opponent refuses that offer. Now let's say that the other party wins at trial, but they don't improve upon the settlement which you offered. Under the civil procedure rules, it would be possible for you to draw that settlement offer to the court's attention and ask that when the court turns its attention to the question of costs, it decides to award costs from the date of the date that you offered the settlement. So you would receive your costs rather than having to pay the costs out. In this way, settlements can be a really helpful and useful tool in litigation, and they're something that litigators make. Settlement offers are something that litigators make a great deal of use of. The civil procedure rules are, as you might expect, pretty involved, and I don't intend to bore everyone by going through them all now, but I do want to talk about the first rule, Rule 1.1, which is so important it has its own name, the overriding objective. And the overriding objective says these rules are a new procedural code with the overriding objective of enabling the court to deal with cases justly and at proportionate cost. So everything we talk about today, and indeed everything that litigators should have in mind throughout, is through that lens, settling the various types of dispute that we encounter justly and at a proportionate cost. So the first area I want to speak about is something that John touched on in the introduction. What happens when founders come together and then fall out? We're going to be talking about the situation in companies, limited companies, but similar concerns could arise in a partnership situation as well. People don't come together in business expecting to fall out, just as people don't get married expecting to get divorced. However, people can come into a company with different expectations, and disputes and disagreements throughout the life of an early stage company are far from unusual. So what happens? The Companies Act has a mechanism that allows the majority, a majority of shareholders to remove a director by simple majority vote. So if two director shareholders fall out with a third director shareholder, it might be they would be able to remove that third person by a simple majority vote, a simple shareholders vote. However, there's no similar statutory provision that would require that departing shareholder to sell his shares. The only way the shares could be recovered is if the remaining shareholders buy them or arrange for the company to buy them. Even worse, depending on the circumstances that the company was formed, that departing shareholder may have a legitimate expectation to be involved in the management of the business, and so if removed, may be able to petition the court for relief. This is a process we call an unfair prejudice petition. Unfair prejudice petitions are a notoriously expensive and time-consuming form of litigation because they are so complex and so fact-specific. And as a general rule, the courts are much less able to deal with questions of fact than simple questions of law, such as whether a contract has been breached. So as an illustration, it's not unusual for parties' costs in an unfair prejudice petition to exceed £100,000. And then we get back to what I was saying earlier about litigation risk and the loser being liable for potentially their own costs and the other side's costs as well. The situation can be even stickier if you have a company where you have two equal shareholder directors who come together to form a business. It's quite likely in such a situation that neither party will have the authority to oust the other. And then the only real solution is either to apply to the court for the company to be wound up, or as John alluded to in the introduction, for some commercial arrangement to be reached where the business is split and the IP is split and the customers are split, for instance. So we've spoken about the legal problems. How can they be avoided? The best way is to agree as much as possible before the dispute ever arises. It's very important to make clear in the company's articles, and preferably in a shareholders agreement and the director's service contract as well, what will happen if someone needs to leave the company? Will the shares be bought back? If so, at what price will they be bought back? Is there a mechanism for a valuer to be appointed? These are all questions that can and should be addressed right at the early stage when the company is being formed and before a dispute ever arises. How do you manage this sort of litigation if it arises? The key is going to be early settlement. So I spoke a little bit about unfair prejudice petitions. The most common remedy that a petitioner seeks when bringing a petition is that their shares are bought out at fair value. And because we know this is probably what they're going to ask for, we can offer that at an early stage. And making such an offer to purchase shares at a fair value at an early stage can protect your position on costs. And obviously, if it's accepted, that can lead to settlement. The other thing to consider is whether mediation will be appropriate. And the answer to the question, is mediation appropriate, will almost always be yes, in our experience. Mediation requires the appointment of a mediator who is a neutral third party who will speak to both sides in confidence. And because they speak to both sides in confidence, they can often identify avenues for settlement that simply aren't visible to the parties in pre-action correspondence. And you will hear us talk a lot about mediation today, and with good reason. So I think that's everything I wanted to say about founder disputes. I think I'm going to pass over to Jans now.
Thank you. So I'm going to start by briefly discussing the Seed Enterprise Scheme and the Enterprise Investment Scheme, also known as SEIS and EIS, and the common problems that both companies and investors are faced with. So for those that don't already know, SEIS and EIS are investment schemes that provide tax reliefs for investors who buy shares in qualifying businesses. Now, the legislation is incredibly complex and has many hidden traps that might cause there to be what's called a disqualifying event, and that results in the investor losing their tax relief. So the main litigation risk here is having a number of disgruntled shareholders or investors whose investment no longer qualifies for this tax relief, and therefore looking to recover their losses from the company and its directors. So the first step in avoiding litigation and having unhappy investors is to obtain what's called advance assurance from HMRC. Now, advance assurance from HMRC confirms that the company is eligible for SEIS and EIS investments. It's that the company is eligible and not the investors are eligible. And often this is a prerequisite made by sort of investors before they invest in your company. And another thing you might find that they ask for is for you to provide certain warranties or to have a provision in the investment agreement that the company and its directors or founders will say that the conditions for SEIS and EIS are satisfied. So you might see a provision in an investment agreement whereby the company and its founders procure that no actions taken by the company will cause it to cease qualifying for the purposes of EIS and shall do all such acts and things that may be reasonably required by any shareholder to ensure that it continues to qualify for the purposes of EIS. So that really the single most important way to avoid litigation is having a very clear awareness and understanding of what the disqualifying events are. Particularly when you are given warranties or if there are certain provisions in any investment agreement. And there are a number of common mistakes that companies make, which I don't intend to run through today, but I would say be aware of them and do get advice on them. So what happens if you are in litigation and a company or a director or an investor has discovered that the company has discovered that there is a disqualifying event and the investor loses its tax relief? As I said, in most cases, the investors will pursue the company to recover its losses. Where you have given certain warranties or there is a provision in the investment agreement that has been breached, either purposefully or unknowingly, you will have a breach of contract claim. And the remedy most likely sought will be monetary damages. And unfortunately, unless you have a strong defence against this, it's generally more cost effective to cut your losses quickly rather than spend time and money in defending against the action. Where no warranties have been given or there is no provision in the investment agreement, you need to ask yourself as founders, as directors and as a company, did you or a director of the company make a misstatement, whether verbally or in writing, that the investor has relied upon as a condition of the investment? So in other words, have you said to an investor, your investment will qualify for EIS tax relief if you invest in my company? Now, in this case, if you have said something like that, the investor may be able to bring a claim against the company and its directors personally for negligent or fraudulent misstatement or misrepresentation, provided that they can demonstrate that they bought the shares and they relied upon this false or misleading statement made by the company or its directors. Now, if there is no warranty or provision in the investment agreement and you have made no misstatement, the investor will be limited in what the action it can take against the company and its directors. So it's important to know the facts of the case early in any litigation, and this is essentially managing litigation. In some more complex and very rare cases, we have been successful in addressing the disqualifying events and navigating our way through the legislation in such a way so that the shares did qualify for SEIS and EIS tax relief, and the problem was essentially resolved. But this is very fact specific and not all problems are capable of rectification. And so with that, I would like to hand over back to Alex, who will now speak about disputes with suppliers.
Yes, thanks, Jess. So I'm going to speak about, I suppose, the first category of contractual disputes that the way we've chosen to parse this up. So these are disputes with your own suppliers. The most obvious disputes with suppliers are where the goods and services provided are delivered late or are of a quality that is not up to the standard that was promised. Litigation can then arise either because you sue the supplier directly or because you refuse to pay the invoice and the supplier then pursues you for a debt. As John mentioned in the introduction, we often see these disputes arise in the context of IT services, either, again, because an off-the-shelf solution doesn't work as promised, or a bespoke solution, while being developed, problems arise, deliverables are delivered late, etc. Because IT services tend to be business critical, we've had clients who have had to stop trading or pause trading, or were unable to secure a next round of investment because they didn't have the IT in place as expected. The first step when considering any litigation is to look to the contract. It's quite likely that the contract will be on the supplier's own terms, and therefore they may limit liability to the supplier or exclude categories of loss. So, for instance, a supply contract might cap liability to a certain financial amount, perhaps equal to the amount paid up to that point under the supply contract. Or it may state that the supplier is not liable for consequential losses, such as lost business or loss of profits as a result of their failure to supply. It's important to understand these limits, both when entering into the supply arrangement in the first place and when considering whether to conduct litigation. Is liability capped at such a level that it makes litigation not worth pursuing? Is the loss that you have suffered a consequential loss or another type of loss which is excluded by the contract? Is the supplier required to maintain a certain level of insurance, in which case it might be that litigation is very worth pursuing? Did the supply contract include indemnities, such as a certain level of access to your systems? And if so, are you in breach of those indemnities? Because if so, that might impact on whether or not to pursue litigation. So how can litigation be avoided? Perhaps the best and most obvious way is through early dialogue with the supplier. The one thing we know about this is that you will have an established commercial relationship with this supplier, and it might be that you can leverage that commercial relationship to resolve the situation in your favor. Otherwise, as with all these disputes, mediation might be an attractive option. It's possible that the supply agreement itself will include a compulsory alternative dispute resolution mechanism, such as arbitration. We haven't spoken very much about arbitration frankly, because it's often just as expensive and it can be just as time consuming as litigation is. But the one big advantage that arbitration has over litigation is that it is a confidential process. And so parties can sometimes prefer it for that reason. And it's often written into supply contracts that parties will arbitrate rather than litigate. So how do you manage a dispute with a supplier when it arises? As with any litigation, the pre-action correspondence is vital in helping each side understand the other's position. Because these supply contracts will always have obligations on both sides, at the most basic level, the supplier will have the obligation to supply and the purchaser will have the obligation to pay for the services. It may be worth solicitors considering whether a counterclaim is advantageous. So for instance, if you are being pursued for a payment of an invoice and the reason you haven't paid is because the services were not provided up to the standard you expected, a defensive counterclaim would obviously be worthwhile. The key point with any supply contract is to have a clear contract with defined deliverables and delivery dates so that each party knows precisely what is owed and when. Litigation arises and is at its most costly when parties are unclear on these points. Obviously, much depends on the drafting of the supplier's contract, which you may or may not be able to negotiate. Of course, this is only one side of a commercial dispute. It might be that you have disputes with your own customers on your own contract. And I'm going to pass back to Yasmin, who's going to speak a little bit about that.
Thank you. So the most common areas that we often litigate in relation to a company's clients or customers is where there is a dispute in relation to the sale of goods or the supply of services. So, for example, when the quality of goods or services is called into question, or if the goods are defective. And the other aspect is where there's non-payment of invoices and essentially debt recovery. So the starting point, as with anything, is to consider the terms of the contract, if there are any. You might have a business to consumer contract or a business to business contract. And depending on the type of contract or relationship that you have with your clients and customers, will depend on which certain statutory duties, statutory terms will be implied. And certain obligations will also be implied. So in terms of avoiding litigation, when you have a business to a consumer contract, the starting point in avoiding litigation is ensuring that you have clarity of terms in your contract and to manage the expectations, such as when payment is going to be made and when delivery is going to be made. And further to this, you should know what you can and can't exclude in the contract as being aware of your statutory obligations. So we have found that common terms that businesses seek to exclude or limit, but are prevented from doing so by the Consumer Rights Act, include things like excluding the right for a consumer to seek a remedy for unsatisfactory goods or to reject faulty goods within 30 days. You simply can't exclude this. Another one is terms that are made in bad faith and that disproportionately favour the retailer, such as hidden fees and charges, are deemed unfair. So, and for business contracts, you cannot exclude the statutory implied term of providing goods of satisfactory quality. In all instances, whether it's a business-to-business contract or a business-to-consumer contract, you should include, as part of your terms and conditions, a practical and fit-for-purpose complaints procedure. You should also include an obligation on both parties to go through an alternative dispute resolution process or a mechanism. And another thing you can include is some form of recommendation to an independent third party who can review a complaints process. It might be that a certain ombudsman applies to your industry or sector, and these should all be used as a last resort before litigation commences. It's a huge cost-saving exercise. But sometimes litigation is unavoidable, and you might either have a claim brought against you or you'll be bringing a claim against a client or a customer. And as Alex has already said, you should engage in early dialogue with the complainant and exhaust all internal complaints procedure, including seeking alternative dispute resolution or mediation before litigation commences. And this is important to minimise costs incurred in resolving a dispute. However, once litigation has commenced, you are, of course, under an obligation to comply with the civil procedure rules, again, that Alex mentioned earlier, and they carry similar heavy consequences as disputes with suppliers. So it's important to seek the legal advice early so we can consider the merits of the case and the likelihood of success and what the potential costs of litigation are going to be. On the flip side, if you're trying to recover a debt claim, such as non-payment of invoices, there are a number of options available to you, such as issuing a statutory demand or commencing a money claim online. So a statutory demand is a written warning that if a customer does not settle their debt with you, you'll be able to bring court proceedings against them. And if the debt is not repaid in full or an agreement hasn't been reached within 21 days of serving the statutory demand, you can then apply to either close or wind up the company. Or if it's an individual, you can apply or start bankruptcy proceedings. It's quite a heavy threat and normally promotes some sort of positive response. This differs slightly from issuing a money claims online, which is designed to be a relatively simple method of commencing county court proceedings for a fixed amount of money. And this route is normally taken where there might be a dispute relating to the validity of the debt. I mean, it goes without saying that for both of these options, they should only follow after you have completely exhausted all other avenues of alternative dispute resolution and trying to resolve it before the matter progresses to litigation. And another point to consider, which we've often helped our clients with, is a bit of the wider picture. So not just looking at costs, consequences. With the various social media platforms and online review forums, it's very easy for customers to write poison pen letters and negative reviews and hide behind an anonymous profile. And the damage that this can cause to a business's reputation is incredibly difficult to reverse. And that's whether or not the reviews are founded or non-founded. So again, it comes back to trying to resolve the issues before it gets to litigation. And with that, we're going to move on to intellectual property rights, and I'm going to hand over to John.
Thanks, Yaz. Well, potential problems faced by young companies and founders when it comes to intellectual property. First and foremost, really, it's not considering who owns what. One area of potential difficulty is IP rights that have been created before the business was incorporated. It might have been written materials for the business, website content. It could have been the registering of a trademark or a logo, for example. Clearly, the company can't be the owner of those intellectual property rights because it didn't actually exist at the time they were created. So there has to be some form of formal transfer of those IP rights from founders or others that may have been involved in software development or wherever it might be before incorporation, a transfer of those rights into the company. This can save lots of headaches later on when it comes to providing disclosure of ownership of all IP rights in the business when you come to investment rounds and or sale of the business. Another area of not considering who owns what is when the business engages contractors or suppliers to design or develop a product or software or a logo. And there isn't any clear written terms between both parties about ownership of the IP rights. And so the default position is that the creator of those IP rights owns the IP rights, and that's going to be the supplier or the contractor. And so when this might come to light and you have to go and have a conversation with the supplier or the contractor in a few years' time, there's no leverage that you have. You can simply negotiate, and that's about it. If they refuse to cooperate, there's little that you can do. You might be able to argue an implied license to use the IP rights for purposes contemplated by the Commission, but that's not going to give you an absolute clear route of title to the IP, and that could cause some headaches later on, as I say, in the DD exercises connected with investment and or sale. Other potential areas for difficulty arise because founders fail to register their trademark and their name at the Intellectual Property Office. It's common, of course, and it goes without saying that founders are going to register the company name with Companies House and also register a domain name for the website. But they often fail to miss registering anything with the Intellectual Property Office. And then what might happen in a year's time or even later, you might find a competitor applies to register a trademark which is the same as or very similar to trademarks used by the business. And in that case, then there has to be an engagement or consideration about whether there should be engagement in a process offered by the Intellectual Property Office for opposing the application based on the pre-existing trademark of the business, which is unregistered, and that can present difficulties. Another area is IP infringement claims brought by parties against the business or brought by the business against third parties where the use of a trademark, copyright, or a design is without the owner's consent. And just then talking briefly about the management of litigation in those areas, I'll hand back to you, Yaz.
Thank you. So if, as a company, you discover that a third party has infringed your intellectual property rights, it is obviously your right to action and commence the litigation quickly. The same will apply in the reverse. So what I'm going to talk about here will be whether or not you're bringing the action or whether you are suspected of infringing another third party's intellectual property rights. So provided that, say, your trademark is registered, the remedy is ordinarily sought for a trademark infringement, whether or not, again, you're on issuing or receiving end of this. In the first instance, you will either receive or give a strongly worded cease and desist letter. And within the cease and desist letter, you will normally insist on certain undertakings being agreed in order to remedy the infringement and avoid court proceedings being issued. And alongside this, and as part of the threats made in the cease and desist letter, you would seek to obtain an interim injunction to prevent the individual from continuing their trademark infringements or from continuing to pass off its goods or services. You would demand for delivery up and or disposal of the infringing goods. And finally, you would seek damages for loss of sales, damage to goodwill, account of profits, which means that the infringer pays to the claimant a proportion of the profits that is made as a result of the infringement. Trademarks can still be enforced even if they have not been registered, and this is through the common law action of passing off. This requires that the particular goods or service has goodwill attached to it, and the benchmark for establishing passing off is generally much higher than that for a trademark infringement, as the claimant has to prove more things such as goodwill, misrepresentation, and damage. So commonly, if there is a registered trademark, a claim is likely to be brought for both trademark infringement and passing off. And this is particularly so if there are grounds for the infringer to challenge the validity of the registered trademark. John, is there anything else that you would like to add on trademarks, or alternatively we can move on to...
No, I think just one point, and I think that is that the law does actually provide protection against the misuse of intellectual property threats to intimidate others. So if a person suffers financial damages because you've made unjustified threats, then they can actually sue you for damages. So the important point to note when you are issuing threats for misuse of intellectual property is to have done proper DD to ensure that you do actually have the right to make those threats. And I think now we're just moving on and talking about data protection. And really, I suppose, avoiding problems arising because of non-compliance with the UK GDPR by young businesses is very much about having a full understanding of the types of data, the categories of data that the business collects, personal data that is, and how it flows through the business, who the data is being shared with, and where the data is coming from, and where physically the data sits. Also, who has access to the data, whether remotely or coming into your premises, whether that's employees, consultants, or suppliers. Having all of this clearly mapped out in the business is going to make it a lot easier if you face any claims that might be made by data subjects, the people whose data you're processing, or claims made by your customers whose data you're processing on their behalf. And also if you have to respond to investigations or inquiries from the Information Commissioner's Office, which need to be responded to in advance of the ICO making a decision about imposing fines. Recent trends that we're seeing around data protection are claims that are being brought by individuals for damages suffered as a result of a company breaching UK GDPR. Damages would generally include damages to cover loss of money because people have suffered financial loss, but more often non-monetary loss, compensation for distress or for depression or damage to reputation. Claimants will rely on breaches by a business of certain principles under the UK GDPR, such as failing to process data fairly, lawfully and transparently, or failing to process data in a manner that ensures appropriate security of the data. Claims are also being brought by individuals because they've been denied access to their data, their subject access requests, or a business has failed to erase data following a request to do so. Most of these data breach compensation rewards now generally begin around the £1,000 mark. And there are guidelines for how much certain data breaches for distress compensation amounts typically amount to. And I do have a list of those. Claimants in these types of claims might expect to recover, for example, £1,000 to £1,500 for breaches of basic personal data, for example, name, date of birth, home, and email addresses. £2,000 to £5,000 for breaches of medical records, £3,000 to £7,000 for breaches of financial information, and £25,000 to £42,000 for breaches that cause mental or physical illness, such as depression. But the claims for distress, which by and large account for most of the volume of these types of claim, are relatively modest. The problem is that you might get a group of claimants making claims arising from the same breach. So when you have a combination of many of these low value claims, you can find that it adds up to a large amount. Any business can be hit by these claims, and when they are brought, they are fought aggressively, and they are made by claimants with a vast range of causes being relied upon, which I'll come to in a minute. So tips and tricks, if you like, for dealing with these types of claims, which are becoming more and more frequent. First of all, don't make any unnecessary admissions at the outset. There may well be a defense. People panic when it comes to data breaches, but there may well be a defense to a claim if it can be demonstrated that there were appropriate technical systems in place and the breach occurred for a reason that was not the fault of the company. And don't be persuaded to accept an argument that claimants are automatically entitled to damages simply by the fact of a data breach. They have to prove damages. They have to prove financial loss, and they have to prove that they are entitled to compensation because they have been distressed, and they must prove that medically. It's important to try and push the claimants on how they've arrived at the value of their claim. Sometimes they just pull a figure from thin air, and so you might seek further information about their legal analysis of the quantum of the claim. And be aware also of tactics employed by claimants in these types of disputes. They're low value, and generally they're not very complex, and they ought to be in the county court. But often claimants try to commence their claims in the High Court, the media and communication list, to increase their prospects of costs recovery, or otherwise simply to intimidate a defendant. The way they do this is by including in their claim for breach of GDPR concurrent claims for misuse of private information, for example, and or breach of confidence. And the thing is that these are often thrown in as a tactic because they're very difficult and complex claims, and it's often the case that they don't have the wherewithal to prove those types of claims. They're not as simple as a UK GDPR breach claim. So when you get these types of claims, consider whether you ought to apply to strike out those more complex claims on the basis that they're not properly made out. And consider also whether you might want to make an application to the High Court to transfer the proceedings to the County Court on the basis that that's a more appropriate forum where the proceedings are less expensive. Some tips for avoiding or reducing the risk of litigation in the area of GDPR. As I've said, know your data, understand the types of data that your business is actually holding, where it's coming from, where it's going to, where it's physically located, who has access to it. Review security measures and make sure you've got strong security measures in place. Always make sure that you meet subject access requests in accordance with the deadlines provided by the UK GDPR. Train employees to be able to report a serious data breach within the 72-hour window as required by UK GDPR, and also conduct due diligence on your supply chains to make sure that your contractors and your suppliers are also UK GDPR compliant, so that that also reduces the risk of you being in breach. And finally, I suppose it's about regularly reviewing your privacy policies. I mean, these policies do tell people how their data is being processed, and that can often change over time. So it's important to regularly update those policies. And with that, I think I'll hand over to Alex, who might take now a look at employment contracts and employment disputes and problems encountered.
Yeah, thanks, John. So employment disputes most commonly arise when an employee leaves a company, either because they've been dismissed or because they have resigned in response to some perceived breach of their employment contract. Such a resignation may allow an employee to claim what's called constructive dismissal, which may be just as unfair and just as actionable as if you had fired the employee yourself. So when I talk about dismissal throughout all of this, bear in mind that that may include constructive dismissal as a result of a resignation. Employees with more than 2 years continuous service have a statutory protection against unfair dismissal. Unfair dismissal being a dismissal that is not following a fair process, as opposed to wrongful dismissal, which is a dismissal in breach of contract. So therefore, the first question that we ask when any employment dispute arises is, how long have they been employed? If they've been employed for less than 2 years, then the employer can usually dismiss an employee simply by giving correct notice, i.e. by not wrongfully dismissing them, not dismissing them in breach of contract. But you do need to be careful. So for instance, we recently had a case where an employer notified an employee who had been employed for 1 year, 11 months, and a couple of weeks that they would be dismissed. And importantly, the dismissal letter that the employee received said they would be on garden leave for the duration of their notice period, rather than saying that they were dismissed with immediate effect. So that notice period, when the employee was in garden leave, brought the employee over the 2 years continuous employment that they needed to bring an unfair dismissal claim. And they then did bring an unfair dismissal claim. If you're curious, we ended up inheriting this case from previous solicitors. We settled that case and then brought a professional negligence claim against those solicitors because they had signed off on this garden leave letter in the first place. And then we settled that case. If an employee has worked for more than 2 years, the employer will need to show that they followed a fair process ahead of the dismissal. So for instance, if you are dismissing an employee by reason of redundancy, you need to show that you have put in place a fair redundancy procedure, which, among other things, selects candidates for redundancy using fair and objective criteria, which are not discriminatory, which I'll talk about in a minute. Or if you are dismissing an employee as a result of poor performance, you need to show that you've followed a fair performance management or disciplinary procedure. An important exception to the 2-year rule, the rule that you can't bring a claim for unfair dismissal if you have less than 2 years continuous employment, is that you can claim unfair dismissal with less than 2 years if it is a dismissal that was as a result of whistleblowing or which is tainted by discrimination. Whenever we're talking about discrimination, we're talking about discrimination under the Equalities Act, which means the dismissal or whatever the act is, it impinges upon a protected characteristic. So this is age, sex, gender, ethnicity, these sort of categories. In these cases, both whistleblowing and discrimination, an employee can bring a claim for unfair dismissal, even if they have less than 2 years continuous employment. And it's also significant because it impacts on the levels of statutory cap in the employment tribunal. Normally, a claimant in the employment tribunal can only hope to recover either the lesser of 1 year of their own salary or a financial award up to a statutory cap, which is just short of £90,000. I think it's £88,000 and change. However, if the claim is for discrimination, then that statutory cap is removed. And it also means that you could claim for other heads of loss, such as injury to feelings, injury as a result of mental health, suffering mental health problems, that sort of thing. And this can really drastically increase the award that is sought by a claimant in the employment tribunal. So it's therefore vitally important to ensure that any policies that are in place are not directly or indirectly discriminatory. As an example, if you are contemplating a redundancy exercise, you need to demonstrate that you have objective and fair criteria for selecting candidates for redundancy. And it might be tempting to adopt a policy such as last in, first out, because how more clear and objective can you get? But if you were to adopt such a policy and that was your sole or your primary reason for selecting candidates for redundancy, that would be indirect age discrimination, because newer employees tend to also be younger employees. So by adopting such a policy, which you might think seems like a good idea at the time, you could be exposing yourself to claims and potentially very valuable claims because of the discrimination angle. So how do you avoid employment litigation? The easiest way is to ensure that you have fair processes that are followed and that you seek advice early. Another important point is that you keep on top of things like performance reviews, attendance records, these sort of things, because if you find yourself in a redundancy situation, these are the sort of things you can point to as the fair and objective criteria for selecting candidates for redundancy. Or if you're undergoing a performance management or disciplinary procedure, these are the things you can point to as areas for improvement. It may be helpful to negotiate a settlement agreement with the employee. A settlement agreement is a contract whereby the employee agrees to waive certain employment rights, or basically all their employment rights, or their rights to bring a claim in exchange for some enhanced payment. They are very commonly used and so can be offered even if the risk of litigation is quite small. Employment cases are usually pursued in the employment tribunal, and there are a number of important differences between the employment tribunal and the courts. I've already spoken about the statutory cap on awards, but there are other important differences to understand. For instance, there are much tighter timescales for a claimant to bring a claim in the employment tribunal than in the courts. Tribunal claims must be brought within 3 months of whatever the behaviour complained about is, with an additional month for compulsory mediation via ACAS. Employment tribunals also usually do not make an award for costs, so the loser pays rule that I spoke about at the beginning doesn't apply in the employment tribunal in the same way. This is a bit of a double-edged sword for the employer, though, because while they do not risk having, there's very little risk that they will be liable for the employee's costs. There's also very little hope that they will recover their own costs from the employee if they were to win. And what is more, the administrative burden of running the case, producing bundles, etc., tends to fall on the employer rather than the employee. Basically because the employment tribunal feels that the employer should usually have greater resources than the employee. So all this means that because of the costs, because of the administrative burden, time, etc., that it might be worth settling cases even if you were quite confident that you would win in tribunal. To assist with this, the employment tribunal offers its own form of judicial mediation. So this is a mediation like any other, whereby the mediator is independent of the parties, is not trying to decide who is right on the law, but is trying to identify avenues for settlement. The difference is the mediator is an employment judge provided by the employment tribunal. We've had cases where we've been able to take advantage of judicial mediation at no extra cost to either of the parties. The employment tribunal have put it in place for us, and it's a very useful tool that I would advise both employers and employees to make use of, because it really is quite successful in reaching settlement. And from the employer's perspective, you can write to an employee and say they don't have a case until you're blue in the face, but that news coming from an employment judge tends to carry a bit more weight. Before I conclude, I want to speak about restrictive covenants. So these are agreements that, or contractual provisions, which prevent an employee from unfairly competing with their former employer after termination. And they're a very common source of litigation and often require urgent injunctions. It's tempting for an employer to have very long and broad restrictive covenants, but that's a false economy because the courts simply will regard them as unenforceable. The courts will generally refuse to enforce a restrictive covenant unless it protects a legitimate interest of the employer. So at the time of drafting, the employer should consider very carefully what interest are they seeking to protect. Are they seeking to protect the client book? Are they seeking to protect confidential information, for instance? And draft the clauses in as tailored a way as possible, and that they should be no longer than is necessary. As a guide, restrictions in an employment context, which are longer than 12 months, are almost never enforceable, and restrictions of 3 months or 6 months need to be quite carefully justified. The only final point I want to note on this is that these restrictions in other contexts can be longer and more onerous. So as an example, a restrictive covenant in a shareholders agreement is likely to be much longer than a restrictive covenant in an employment contract, because the courts treat employees and employers as on an unequal footing. There's a difference in bargaining power between employers and employees, whereas they consider that all parties to a shareholders agreement are sophisticated commercial parties who are capable of looking after themselves in the negotiation. So restrictions of 5 years are not that untypical in a shareholders agreement. And with that, I want to pass over to John with some concluding thoughts.
Just some concluding points really from today's presentation. And the first really is that litigation can indeed be avoided, or at least managed cost effectively, by using mediation as an alternative dispute resolution. And remember that mediation can be entered into both before proceedings have been commenced or at any time after the proceedings have been commenced. And I just got some information here from the Centre for Effective Dispute Resolution, which is one of the largest mediation service providers in the UK, which published its 9th biannual mediation audit in 2020. What that audit said was that there was a 38% increase in the annual number of mediation cases since its 2018 audit. And interestingly, the report stated that overall settlement rates have increased to a rate of 93%, with 72% of cases settling on the day of mediation and 21% settling shortly thereafter. It also reported that these figures sit with anecdotal evidence of the recent popularity of mediation and the online mediation of commercial disputes becoming mainstream, including for high value and multi-party disputes. So really, this is a big message about avoiding litigation. Where the parties to a commercial dispute both agree to go through a mediation, there's a huge potential for settling that dispute by agreement. Both parties clearly compromising, of course, but it can be done cost effectively and it can be done flexibly. Most mediations are now online and can be done from the comfort of your own home or your office without having to attend any particular venue and without having to face your opponent. The costs of mediation vary according to the value and complexity of the actual dispute and the experience, if you like, of the mediator that you might require to assist with the mediation. Most mediation service providers will offer a fixed price mediation for low value, less complex claims, starting at around about £750 per party. And the cost of mediators can be anything from £1,000 to £5,000 upwards for more complex and high value claims. By and large, the types of claims that we're dealing with, particularly for the young companies, would probably involve mediation fees of approximately, or fees charged by the mediation service, that is, of approximately £1,500 to £2,500 per party for the mediator. So what's the message there? It's mediate, mediate, and mediate. Another theme that comes through really is that disputes and the risk of litigation can be avoided or at least reduced by having the right protections in place in the first place. And this really means having fit for purpose shareholders agreements. It means making sure that your terms and conditions are fit for purpose for your business with appropriate caps on liability. And also they have exclusions of liability for certain types of consequential losses. And also ensuring that your terms might have alternative dispute resolution clauses contained within them, forcing the parties to go through a mediation in advance of any proceedings being commenced. One thing to be aware of in relation to employment disputes is that half of tribunal cases arise from the correct procedures not being followed. So as Alex referred to, whilst young businesses can't afford the luxury of an HR department, what they might do to minimize claims is having proper contracts in place, proper appraisals, and also having proper procedures in place dealing with grievances and disciplinary proceedings. If litigation can't be avoided, try to engage at an early stage, and remember that you can try and bring about mediation after proceedings have been commenced. If you find that you've got an opponent who refuses to engage in mediation, you might try and put pressure on them by explaining that the court rules require the parties to consider whether ADR, alternative dispute resolution, would be suitable, and if so, to agree what form of ADR procedure they should adopt. And also to provide evidence, if requested by the court, that ADR was considered. And you might also point out to a reluctant party that a refusal to mediate can give rise to costs sanctions at the end of litigation, whether that party is successful or not successful. And just one final point, Modwena, before we hand back to you, is that young businesses really should keep in mind proportionality of costs and management time caused by the litigation versus the likely return and how long the litigation process might take. So, sorry, Modwena, if we went over, hand now back to you. That's okay.
Thank you. I've rarely had such a useful hour. I think you've covered an amazing amount of stuff. I'm very conscious that we're finishing at 10:30. We've not had any Q&A put into the box. So what I'm going to suggest to people, we've had one just come in quickly. But so we'll just take one question from VJ, if that's all right with you, Keelan, just to do a little bit of audience interaction. So I don't know if you can see this, can the mediation service assist with setting international disputes between two non-UK companies? That's quite a challenge. Thoughts on a postcard, but could we try and keep it to a minute or two? Because I'm conscious Keelan has got lots of interesting things to say. So.
Yeah, a mediation service may well be able to help. It may well be that they need to engage another mediation service that may have mediators who are qualified and have experience of the laws which are relevant to the dispute. So yes, I mean, it's quite possible you could find a mediation service provider to help find you the appropriate mediator for that dispute.
Oh, thank you. Well, thank you very much indeed. Keelan, I'm going to ask you to turn on your camera now, if you could. Hopefully he's still there.
Yes, I am. Let me just send a message here. 2 seconds.
Okay.
I got a call there just at this moment. Hi, Madeleine. How are you?
I'm very well. It's so nice to see you, Keelan. We're here to sort of create some amusing anecdotes of how both of us have been absolutely brilliant and never faced litigation. And it's always, even if it has, it's always been marvellous, and we've solved it immediately, haven't we?
Absolutely. So this is the litany of war stories, is it?
Yes, please. I thought it'd be quite fun. I thought it maybe we'll do a bit of a sort of a to and fro. So I'm going to tell you my favourite employment story.
Okay.
And then perhaps you could tell me something funny about or interesting that's happened with you around litigation. So I had a situation a few years back, I can be very diplomatic clearly, where I had somebody who, in my business, spent an awful lot of my money, apparently authorised, and then skipped off and got another job, and then brought a claim against me as the employer for treating them unfairly, despite leaving me with quite a significant financial hassle. It was very interesting because they were an employee, so I was caught under an employment contract issues. They went to, need to say the lawyer representing people who attack you, they're always nasty. They're very nasty, sort of aggressive lawyers, started writing me rude emails. Anyway, how I resolved it was I always talk to lawyers when it comes to employment. So I have a friendly lawyer who I always ring up about these things, but actually the majority of the work I got settled through ACAS, which is, I think, a big tip that I'm not sure many people know, but ACAS are a free employer-employee dispute resolution service. They're not just for the big unions, they're for anybody. And they put in place a mediator to resolve the issue, and they don't charge you anything.
Yeah.
But if you go to, also, if you were to end up in court, you are always offered mediation if you try and bring a case. If somebody tries to bring a case against you bring a case, and if you refuse ACAS, it actually looks worse if you do end up in court. So there's a sort of double win if you have any employment issues, and it moves actually into being a more formal dispute. Ring up ACAS and ask them to sort you out.
Yeah.
So that's my first tip on 4 stories. What's yours, Keelan?
Well, I have something similar, and again, it's a lot of the stories I have probably pertain to our investee companies, but this is one that it pertains to us ourselves. But I must say, I thought that was an excellent summary of from Gannons, and there was a lot there I related to, including the entire emphasis on mediation, and sort of similar to what you're saying about ACAS. But we had a situation years ago where we hired someone, and we knew pretty quickly that it was the wrong person, but they had just passed their 3-month probation period, and so we kind of, like happens with so many sort of small and growing businesses, you're so busy that you overlook really basic things like that. Anyway, sort of a few weeks later, we had to get rid of her, and we consulted lawyers because, as you say, in things employment, you want to follow procedure, and I know that Gannon's covered that in some detail. But anyway, we had a situation where we followed everything. We paid all the holiday pay and all the good stuff you're supposed to do. And we had a letter, and then included that usually is you pay them whatever amount, let's call it £500, so that they can get a lawyer to review the document and make sure everything's in place. So we did that, and unfortunately, I guess we ran into, or this particular employee picked an ambulance chaser. And the next thing, even though this person had worked for us for a matter of a few weeks, they somehow decided that we owed this person £50,000.
Oh,
We said, well, our position is we owe you £300. And anyway, we went through this long process, and the mediation didn't work. Okay, and it was going through an employment law to the employment tribunal. And I thought it was very interesting how Gannons was saying that costs are attributed to the respective parties, not to the winner at the expense of the loser. But the judge actually opined that because we caught her, let's say, being economical with the truth a few times, that he's minded to award us costs, and basically said settle up, because you've been caught maybe being a bit liberal with the truth. Anyway, to cut a long story short, we ended up settling for £300. So she kind of immediately came back and said, no, 20 grand, and then 10 grand. And we were like, no. But the thing that came out of it is, although it was a minor amount of money, it was an enormous amount of time and management time on this issue. And it was a real waste of time. It was a waste of everyone's time, but particularly our time. It really just shows, if you can't avoid these things, you obviously want to. But unfortunately, I guess the commercial reality is, and I suppose where things like ACAS and mediation are particularly good, is sort of draining these situations of emotion, because that's what invariably sets the, it's probably very similar to a divorce court, but trying to get the emotion out of it, I would say, from a commercial point of view.
I think that's so wise and profound. I think these things happen, and particularly employment can get quite emotional. I was involved in something which didn't involve me. It was a firm I was advising, and they had someone bring a sex discrimination claim, a woman against a man, and they were all very metrosexual, liberal elite type people. So they were really offended by this idea of a sex discrimination claim, because they thought they were. But what we found is people got very emotional, and that's why using things like ACAS and stuff really help, because they just drain, as you say, they drain that extra unnecessary energy and turn it into just, what's the facts, let's sort it out. So I've got another interesting thing I found is, and maybe Keelan's got some stories, which is customers. And my sort of learnings of, I've never had a big dispute with a customer, but that's partly because I try very hard to work out and make sure it's very explicit what I'm doing for them, so the contract is very clear. And I also do things like make sure they set good payment terms. I set good payment terms so I get paid, so that therefore I'm not unhappy because I've been paid, and hopefully I've done good work for them and they're happy. So that works. But I have had situations where after the event, people have said, oh, I think I want this or that. My reaction typically has been just to settle very quickly and broadly give in to the customer as long as it's reasonable, and nothing that's ever happened to me has never been egregious. So I've not had to have to face an egregious claim against the customer. But I've had people say, well, I'd like this or that, or could you change this? Have you ever had anything around customers, Keelan, where you've had some big dispute?
We don't have that much. I mean, I'd say one thing that happened last year. So just for anybody who's one of the an attendee, we as a venture capitalist, we have about 35 companies that we deal with in various stages of their growth. And I mean, last year, I would say the biggest sorts of commercial disputes was with landlords over trying to come to some settlement with because no one was using their offices. And there was varying successes. There were some people who just gave sort of 3 or 4 months of rent free, and there were others who wouldn't compromise. And there were some that went, most of them settled in the end, but it got a bit heated for a while. But you know, a lot of our companies are dealing with large enterprises, and I would say the one of the maybe not necessarily leading to legal, but one of the common disputes is like the time to get paid. Because of course for an SME that's always an issue. Cash flow is an issue for all companies, but that can often lead to sort of heated exchanges. We have had a few IP disputes. I know Gannons was mentioning that, but generally speaking, no, customer disputes are not. They can usually be resolved, usually because the two parties want to keep on a relationship. You know, if an employee leaves, that's, you know, your relationship's over. You behave in a different way than if a relationship's ongoing, assuming the customer and the supplier are happy with the relationship.
Actually, I do have one funny story to tell about that. You prompted me, Keelan, where I had somebody who worked in an organization I was in, and they had a restrictive covenant, and they went to work for one of the customers of the company. So they hadn't understood that not doing business included not taking employment from. So this was, anyway, this situation was fine. It was the right decision for all 3 parties that this person moved from the supplier to the customer. But there was a very funny, it's the only time I've ever seen anyone go green when I was deputized to go and talk to the customer to explain that there was this contract in place which was now in breach. And it was all quite difficult because a resignation had happened, and but the new employment hadn't actually yet started. so it was a real pickle. And anyway, it was quite funny because, as I said, I was deputized to go and talk to the customer about this because just legally it needed sorting out. I mean, there had to be a waiver written, etc. Anyway, this person, I just said, "Would you like to sort it out, or should I tell your personnel department?" And they went completely green and said, "We'll sort it out really quickly."
Well, one thing. I'm sorry.
Yeah, no, you go on.
I was going to say one thing that was brought up that I found interesting, not that we've had a problem with any of our companies, but there was a bit of a discussion there about IP disputes and consultants who contribute to IP. I thought that was particularly interesting because we have it made me, I think it's something I'm going to look into, because we do have a few companies that do that, where they effectively work with consultants. And I don't think that's unusual with young tech companies, where they don't want to bring on full-time staff, and they do use consultants, and sometimes lean on them fairly heavily, usually with the idea that as they move to the next level, that they replace those consultants with full-time staff in whole or in part. But it made me think about IP disputes with people who are not part of the group, but who have had some influence on the IP of the company. So that I found piqued my interest.
Yeah, what I do now to solve that is I give consultants, I put them in an unapproved share option scheme, and one of the conditions of accepting the share options is that they hand over all intellectual property as a generic anything they do.
Yeah.
I don't know whether you've tried that route, but I found that works.
Yeah, I mean that's
quite neat.
We do have provisions like that, but it may be something worth looking at, because I'm sure that can get quite complex in part.
Yeah. Well, it's not been tested, but it seems to work legally, because you're giving them reward for the work they've done. So there's I don't know, maybe Gannons would know what the phrase is. There's a thing where, isn't it, for a contract to be valid, there has to be an exchange of value properly. I think that's right. I don't know if Gannons are still listening and have any thoughts.
Yeah, it's consideration, constituent parts, an offer and acceptance, intention to create legal relations, and consideration must be given as well.
Yeah, so that's, okay. So I think I'm in the right. Okay, thank you. Keelan, what about, because we've got about 15 minutes left, and of course, I'm sure we could talk for hours about this. What about shareholder disputes? What fun and games have you seen there?
So are you talking about the people who are investors, or say people who are founders?
I think just whatever's juicy, to be frank, because I know people will be interested in hearing stories that sort of make the point in a...
Certainly an area that is of interest for startup and scale-up companies is oftentimes founders fall apart for whatever reason, and the leaver provisions kick in. And we've always been, of course, when you first get involved with a company, bearing in mind that it's a relationship as a venture firm for we should count on sort of 6, 7, 8 years. It's well known that certain key staff can fall out, whether they're founders, co-founders, or just senior personnel. So often people, when they enter into contract, they want those leaver provisions to be as tight as possible, i.e., they're over soon. And they actually, it's counterintuitive for some co-founders, but if a co-founder is to leave, it can really complicate things if someone leaves and has too much of a stake in the ongoing business when they're not contributing, and it can harm the prospects for everyone, including the person who left, because it makes it harder to fund the company if they own too much and they're not contributing, and then therefore their stake can be worthless in extremis. Well, not even in extremis. It's not unusual. So the lever provisions, I think, is something that for startups and scale ups is very important.
Yeah, I think that's true. One of the things I've heard about is often shareholders, particularly angels, they sort of demand information rights. And what happens is over time, the company's desire to send over information weakens as they get more busy with running their business. Have you seen that happen? And have you ever seen anyone try and call on the provisions of a shareholders agreement to say, where's my information?
Yes, I have, and also it becomes impractical if the company becomes a certain level, or when you're selling a company, people who have a relatively small part want to be involved in the negotiations, which is simply impractical, and sort of want to go through all sorts of documents. And there's a lot of documents when you're selling a company, and you're sort of, well, you put in £10,000 8 years ago. You will be treated fairly, etc. But to be involved in negotiations, or to assume that somehow your input is required, or even desirable, that's always an issue. We're selling a company right now where we're dealing with lots of angels. It just makes you think you want to get them all in a nominee account and have power of attorney over it, but that's not always possible.
And have you found people ever trying to actually say, but it's in my shareholders agreement, I should have this information? And because I have come across people sort of trying to turn to the shareholders agreement and say you're actually in breach of the shareholders agreement by not giving me this information. Have you come across that?
Yeah, but never to the point where we can't satisfy it, I must say. It's more of a hassle than just saying, okay, fine, we'll get you the accounts or get you whatever, but not for either the articles or the investment agreements never allow them in an M&A transaction to be that involved, so we don't have that issue. But yeah, there are certainly some times where they want a lot of servicing, and to a certain extent that's fair enough. But I guess also one has to remember that the company 7 years later is usually in a very different place, particularly for someone who was very involved at the beginning. Because often, as you know, when an angel can bring a lot of value to companies particularly in the early stages. Sometimes it's not really a legal issue, but sometimes you just see that they maybe don't feel as wanted or needed as maybe they did in the past.
Yeah, they're very interesting. Have you ever seen anything around an actual intellectual property fight? Because I did work with some intellectual property insurance people a few years back, and I've got some fun stories to tell, but you go first if there's anything around intellectual property disputes, anything ever particularly interesting that's arisen?
I did actually. We once, before we had a fund, we had a corporate advisory business, and M&A and that kind of thing, and we worked with a company, an American tech company that had awesome technology, like just way ahead of its time. And the only problem was the management was horrendous. But the engineers are fantastic. And I mean, this IP was so ahead of its time that there was, I won't mention the name, but there was a very prominent IPO on NASDAQ this, was it last summer or earlier this year? I forget now, but some months ago, 6-8 months ago. And the IP that this group had was so tightly, like so brilliantly done that even today, a lot of companies have been violating it. And I'm talking about big companies like Google and Facebook. And this one company in particular that was coming to market, the inventor, who has a very senior position in a company we all know, he was talking about coming to a serious settlement with this company with the possibility of stopping the IPO. This is a multi-billion-dollar IPO. So it was quite interesting the way IP developed like 13, 14 years ago is still that robust. But usually the IP disputes are not, one of the things that happens with a lot of founders, particularly if you spend a few million on R&D and millions or at least hundreds of thousands in R&D tax credits, there's often a feeling that the IP is worth something for software companies, which is mostly what we deal with. And it's not. Usually, this was quite an extraordinary situation, but usually it's really not worth it. Like software turns into vaporware, even though what you've developed is very, it serves a purpose. If it has failed commercially, it's usually not worth anything.
Yeah, I have a lovely war story, which is not my own. It was recounted to me by someone in the insurance industry, where a company got involved in an IP dispute, and they were being attacked by someone else, and they believed they were going to win. So they called on their shareholders to invest money into the company to pay for the IP lawyers to fight this claim. So the money went into the company by the shareholders in full knowledge that they were funding the people to fight this claim. Anyway, the litigation all happened and the people lost. So the people attacking them won their costs and a claim for damages. And this is where it gets really interesting, because the angels had invested in the company specifically to fund the litigation claim or defense. They became jointly liable for the claim, and they were personally called for the damages.
Oh, wow. Okay.
Isn't that scary?
Yes, it is.
So it's a really interesting example of how some contract law works. If they'd just invested in the company to fund it and then said it was for working capital or for marketing, they wouldn't have made themselves, but they made themselves privy because they specifically invested to pay for the IP lawyers.
Well, slightly switching, but getting back to what we were talking about earlier in mediation, and where I guess the message comes across both from the lawyers, but also I guess from me as a practitioner about mediation and compromise and draining these situations of emotion. Rarely have I seen, when you have larger disputes, it just becomes costly. But with sort of startup and scale up companies, if these disputes drag on, they can actually threaten the existence of the company.
Yeah.
And it's remarkable how many times people, all of whom will lose if the company loses, but continue on going down a non-mediation path. It's sort of like a scorched earth process where everybody suffers. So I think that the idea of mediation for particularly the small growing companies, who after all are usually, if they're succeeding, they just don't have enough time in the day. And the last thing they need is to spend extremely time consuming, legal action. And, there is sort of data access and access requests. One of our companies just had this recently as an adjunct to an employment dispute, and the amount of management time spent on that. Now, probably their lawyers were doing this as a negotiating ploy, but the amount of management time spent on that could have been doing something a lot more productive. And this person who is a disgruntled ex-employee, it potentially affects their economic interests. So it's one of these lose-lose situations. So I think if we come across with anything, it's try to mediate and take, try to cool down the situation. And come to some sort of set. It sounds very common sense, and it's harder in practice, but it really benefits all. Let's put it that way.
I think that's right. The other thing I found is that there's I was talking to someone else. They had this experience recently whereby there was somebody attacking and somebody defending, and the defense, whenever an attack came in, so panicked, stopped everything, thought up the best possible reply, and then lobbed it back over the net. And the attackers, it was really interesting what they did. They would then wait like 6 weeks before they then replied. So basically they were discombobulating the whole situation by using time to sort of, so defense sent back stuff saying, well, no, this is why your attack is wrong. And then stony silence for weeks and weeks and weeks. And then suddenly another salvo. And that was a really, I don't know whether either Keelan or Gannons, but I think there's also, we encourage mediation, but there's a lot of tactics and games played by people litigating. So it's like litigation lawyers will typically write really aggressive letters. Really, the tone is just horrible. And but it's all designed to achieve the outcome. And I did speak, John, you may have views on this, but I did speak to a litigation lawyer once. They said, well, we don't care. Our job is we don't care about relationships. Our job is just to win. And therefore, so they have a completely different approach where, Keelan, what you and I were saying about, like, it's mainly most people want to keep relationships going, even if there's a problem. If you actually have a litigation lawyer, that's not how they think. They're trained to just win the battle. Is that fair, John?
Well, some are, I'm afraid to say, aren't they?
Yeah. Not all of us are.
No. It depends, but yeah. And that's sometimes the approach businesses want.
Yeah.
Yeah. So, yes, absolutely.
So, yeah, but do you find there's that things like using time and language to try and get an advantage in the sort of, let's call it negotiation, try and find the right word, but
sure. Yeah, absolutely. It depends on the circumstances, but it might be. And oftentimes, so because the civil procedure rules will specify that certain things have to happen on certain dates. So for instance, if you're dealing with a large claim, there will be a stage called cost budgeting where you all have to stand up in front of a costs master and justify yourselves to them. So before that stage is quite a good time to start pressing for a settlement immediately before that happens, or just before witness statements go in, or just before disclosure is due, for instance, because there are certain timetable deadlines. You can find that parties sort of drag their feet up until these deadlines and then put all the pressure on.
Because the next stage is going to inevitably involve a lot of work and therefore a lot of money.
Exactly.
So the stakes raise, don't they, as you go along? But yeah, you can have periods where it's kind of a little bit dormant and it takes a backseat. And then suddenly the timetable kicks in and you think, oh gosh, we better start looking at where we are with this. Start thinking. Yeah.
I actually have a question for Gannons. It's something that you brought up and it piqued my interest. And it was about restrictive covenants. You started off talking about from the employer point of view, the employee, and you mentioned that 12 months, and I guess this is fairly well known. It's very difficult to preclude an employee from restrictive for 12 months or whatever. And you're mentioning 3 to 6 months has to be justified. What about a founder? Because you then differentiate with people who are shareholders. A founder who leaves a tech company, would a 12-month exclusion from them joining another similar tech company be considered by the courts to be unreasonable, or is that a reasonable amount of time?
Well, I think it could be now, and perhaps this is my fault for mentioning time limits, because that's really what we tend to deal with, but. And it's usually the time that is the unreasonable thing with a restrictive covenant. But I think what you need to do is you need to put yourself in the position of, what am I trying to protect, and how long do I need to achieve that aim in protecting that? So if you're dealing with a founder who has absolute visibility and absolute knowledge and absolute power about a business, there really is, there's almost no upper limit in terms of time. But don't take that to mean that the employment tribunal would, or a high court considering an employment contract would consider an indefinite restriction to be reasonable. I think 12 months is sort of the rule of thumb as the upper end in an employment context. In a sort of another type of commercial agreement, they might consider a longer restriction. And I think a founder is likely to also be a shareholder, and you might consider putting restrictions in a shareholders agreement. That was the point that I was getting at.
Yeah.
Or if there's no shareholders agreement and you're buying shares off them, it presents an opportunity in the share sale agreement to include those types of restrictions, which, because it's in that type of agreement, is likely to be able to be for a much longer period of time than 12 months.
Right. And particularly if you can prove that it might have an existential impact upon the company.
Exactly,
Of course. Yeah. I mean, the reason restrictive covenants are used is because if drafted correctly, they are enforceable. It's easy to get the message across that restrictive covenants are often not enforceable, but oftentimes they are enforceable. And we have plenty of employers or departing shareholders, whatever, who call us up and say, do you think these are enforceable? And we have to say, yes, probably. You should probably not compete unfairly.
Okay, interesting.
I'm conscious we've hit 10:30, and actually I've got to get onto another call, which is slightly embarrassing because I don't want to do this and I'm enjoying myself too much. But hey ho, I'm going to suggest that there are a few questions in the Q&A. If the people are still there, VJ, Martin, and David, I wondered whether the Gannons team might be able to look at them on the system and just quickly type in some answers. And then everyone else who has, the rest of us can all sort of go and hopefully have an excellent day. But those three who've asked questions, perhaps that's an opportunity for the Gannons team to put in a bit of answer to them. Is that all right?
Yes.
Yeah, sure.
So I think I'm probably leaving hopefully three people in the audience. I can't see the audience, so I don't know if they're still in the call. And but for about five minutes, if that's all right. So I'll leave the call open, but I'm going to disappear if I may. So. And all I can say is thank you. I mean, I totally agree. This was fantastic. I really enjoyed hearing you talk, guys, from Gannons. And Keelan, you're always full of wise information. I hope we can meet again soon, maybe in the real world would be nice. But if I don't see you before, it's too early to say Happy Christmas, isn't it? But you know what I mean. Have a great rest of the year. And we'll catch up very soon. And to all the audience, I can't see you, but I hope you're having a great day and have a great week too. So thanks very much and bye-bye.
Okay, bye.
Thank you, guys. Bye-bye.